the plea bargain matter. Mr. Nyekachi Ubani joins us now. He's a legal practitioner. Thank you for coming on this morning.
Thank you, Chamberlain. Good morning.
Well, arguments are being advanced for and against this plea bargain matter. You heard a previous colleague of yours who did say, well, yes, we could look at it in a certain way. You can have the NJC come and look at that in the framework of a criminal justice system. What's your thoughts on this?
Well, before you have the NJC come in, there must be an elaborate provision of plea bargaining in our jurisprudence, and then the principles, the legal safety valves, all have to be provided for in order to avoid abuse. Already it was, somebody has said, smuggled into the EFCC Act under Section 12(3) of the EFCC Act of 2004. And of course, you see the abuse that particular legal concept has really suffered in Nigeria. Look at all the people that have been convicted on plea bargaining arrangement. Was it done in the interest of the public? Issue of public interest comes in. Take, for instance, the former governor of Edo State, who was alleged to have an allegation, stolen several billions, and then he came to court with 3 million in his pocket, and then paid off. And then the issue will go home and see no more. Now, if you take into cognizance even the legal concept of plea bargaining, that we talk about American judicial system, where it came from, if the prosecution is very sure with his facts and evidences that he will secure conviction, he doesn't go for plea bargaining. The concept came as a result of the fact that we want to make sure that we don't delay cases unduly. And they spend so much money also in prosecution of a case, and they don't want taxpayers' money to be spirited away frivolously. So to end trial speedily and ensure that they get a conviction in a matter they're not too sure, most times they have a cost to it. It's not in every case that the American system encourages plea bargaining. Now we want to import it in a manner that is not even properly defined through the EFCC Act, and we look at how many abuses has been subjected to. The Lucky Igbenedor's matter, the Halliburton's case, the Siemens case, the Tafa Balogun's case, and then of course Alamesia's case. In which of these can you say that the public interest was actually protected? And of course, you want to take into cognizance the real motive of plea bargaining. Take the story of what took place in the Bible, where Zacchaeus came to see Jesus. He was a tax collector, and the moment Christ came into his house, there was no judicial proceeding. The man pronounced himself guilty and said, "Look at what I'm going to repay. Half of my properties will be returned to the poor, and then whosoever I have extorted money from, I will return fourfold." That's restoration fourfold. That is real.
So what was he bargaining?
That was pure plea bargaining. There was no sentence.
Okay, he sentenced himself.
He sentenced himself, and they show remorse. I said, "I'm returning fourfold." That is what plea bargaining should be, for us here. Somebody, he have stolen billions, and you ask him to pay only small change, and then the man goes home and says, "Go and sin no more," and all that. Then you are destroying our legal system. You are not taking into cognizance our environment and our problems and our peculiarities. The issue of corruption that has destroyed the fabrics of Nigeria.
Is it not possible? The CJN said it is. The plea bargain is a novel concept.
That's right.
But it has no place in our law, substantive or procedural.
Yes.
Is it not possible that there's a way this can be worked into our system so that at the end of the day, the judicial system is better off? I mean, the courts are decongested, the prisons are decongested, yet justice is meted out.
Yeah, the CJN, he means well, because you see, when he said there is no adequate provision, is very, very, very much right. The one they have in the FCC Act is about issue of recovery. I said recovery. There was no elaborate provision as to the principle, to even the limitation, and then the legal safety valves you have to provide, and then to avoid abuse. Because if it is not well provided for, people will have very cost abuse. So it is possible there is a bill now. The EFCC now mentioned is before the National Assembly. We have not seen the bill. We need to know the provisions that have been made, and also the issue that our environment is so. How do you describe it? It's a bit that you have to be very careful, so that you don't attract cynicism to the judicial system, where when it concerns only the big men in this country, we're eager to pass such laws in order to benefit them. And then when it concerns the poor man, you are not eager, because this law is for the big men, the elites, who are looting the treasury, who are ensuring that all our money are being transferred abroad, and then you are now making a provision for them to, when they come in, when they are being charged, they plead for a lesser offense. I mean, and then go home with the rest of the money and return little.
He says here that it could be applied in 2 cases, for major cases or minor cases. So we have to decide how we want it administered, because in some jurisdictions he says it's only for major cases, not for minor cases.
Yeah, because EFCC is meant for money laundering and then looting of the treasury. So it is meant for major cases. Now, in our, unless Lagos State now that has made provision for it in the Administration of Criminal Justice Act law. It wasn't there in any of the states. Now Lagos State has done that. Now we must also make sure that it's also, if we want to apply it, but we have to be careful. If Americans want to pass any law, they bring in experts, they bring in sociologists, they bring in the what you call the philosophers, they bring in even the psychologists. They look at the implication of that law for the application, in the society, so that you don't just go and make a law without taking into cognizance your peculiarities, your environment. American is working out for them, because if you are a convict, that is. There's issue of sense of shame. You may not be seen in public life, but here you are a convict. You are an ex-convict. You are a criminal. The more they give you national award, the more you are recognized, the more people begin to hail you. So we must be very careful in order to put a legal system that will really discourage people from committing crime and being, with impunity.
But in this case, sorry, Emmanuel, it was saying that it doesn't bother on the sentence that will be meted out or the judgment ultimately.
Yes.
It's a different case entirely. Because if you're a convict, some benefits you'll be denied of.
Yes.
You can't participate in any elections, so many things. So what if we focus on that? Spell those aspects out, say, well, as long as you be convicted, you not get some benefits, and then the plea bargain is on the other side.
Yeah, you find out that, as I said earlier, our environment is very peculiar. Now, if you are convicted, and then you're a very big person in this country, don't forget that they can give you what you call state pardon. And you still become very relevant. And as I said earlier, our value system has so much deteriorated that even if you're an ex-convict, nobody cares. So far you have money, you buy your way through, people begin to hail you. In fact, the more, as I said earlier, you were a criminal in this nation, you are more respected, you are more, people praise you the more and all that. So there is the value system that they have in America, where if you want to come into office, people will begin to look at your history, even who was your girlfriend when you were in primary school, how was your mother and all that. They look into all that. Here, it does not matter. In fact, the more you are into more things that are criminal, they begin to praise you and hail you, and you come into the system. So we must distinguish these things so that
if you
answer ex-convict here, it doesn't matter. If you have money, your ex-convict still listen, will not be, you are being recognized more.
Sure about that?
Our value system. I'm talking about Nigeria now.
That's not for the judiciary anymore.
Yes.
Because if it is that the ex-convict stigma doesn't matter.
It doesn't matter
to anyone, to the citizens.
Yes.
Because that's who the society is.
Yes.
It's not for the judiciary to worry about, because it would seem that even if they go through the full judicial process, the full rigors of trial, and are eventually sentenced and jailed, chances are that they will still come out and it doesn't matter that there was plea bargain or there was no plea bargain.
Yeah, you see, what is the principle behind issue of sentencing and criminal prosecution is to deter. If they hire the sentence, it makes others to feel afraid committing that same crime, because when they commit it, these are the consequences and these are the things that will follow in terms of stigma and all that. But where the system now in your own country, you recognize an ex-convict, you respect him because he has money, then the judicial system must be careful in not encouraging it, in not encouraging people to go and loot when they know at the end of the day you return little. The only thing is that you are an ex-convict. The point is that you return little and go home and enjoy all your wealth. The society will still respect you. You will still become relevant in your community. So the system must work against that. The legal system must discourage that, and then take into cognizance you have value system. If the value system does not discourage people from committing crime, then the system must also work against it in order to ensure that when you commit a crime, you are punished for it. Now the FCC is throwing up their hands with this issue of plea bargaining and say we cannot get conviction with all the governors they have charged all these years, no conviction whatsoever. With this plea bargaining, what will happen now? Immediately all the governors will take cue of this, and all of them will enter into plea bargaining. They go home with all that they have stolen, and then you just call them ex-convict, and they are still relevant in our society.
But do you still see this happening? Because you see, in your argument, you seem to be saying that plea bargain by itself is not an entirely bad thing.
That's right.
What we need to do is set out the ground rules.
Yes.
Are you not confident that the ground rules that we're about to set out with this bill that the EFCC has presented before the National Assembly, we could actually be able to make it an effective tool of prosecution?
All our laws are mostly observed in breach, even if the law is there. They look for a way to mitigate it. They look for a way to abuse it. And that's what I was saying, look, where are we coming from? That's what I said, even historians will be involved in the lawmaking process, Let them look at implications. Where are we coming from? Why is Nigeria the way we are today? There is no employment. There are no infrastructures. It's because of corruption. And if any government comes in and tackle corruption, I can assure you that Nigeria will hail that government. It will be written down in gold. Now, if a government comes in and begin to now formulate a legal policy that will encourage people to loot, at the end of the day they return little and they go home enjoying their this, and then you have not helped Nigeria. You have not in any way enthroned integrity in the system. So I'm saying that we have peculiarities. Our environment is quite different, so we must be careful in this issue of plea bargaining. We're importing from America into our legal system because our environment is peculiar.
All right, look at the scenario, the examples of the cases of plea bargaining that we've had.
Yes.
The first one, yes, it was an error. They say it was a slap on the wrist.
That's the second one of Does
yes.
Okay, fine.
And then you have 125 billion, which the council, Mr. Shutu says, at least if you get 125 billion, that's no small money to have returned.
From which of them? From a Benedo's case?
Oh, sure, yes. Compared to the first time where it was more like a slap on the wrist, and to the second one. So that improvement seems, that progression.
Yeah. Let me tell you what. Let me tell you what potential criminals will do concerning this. The entire properties that we buy now will not be in their names. They may not even use any of their relations in buying the properties.
Shouldn't that be investigative?
Fine. Do you have the instrument? Do you have the capacity to investigate and trace properties, looted properties to family, not family members now? Because what they're saying, the Nigerians they're very smart. The moment you introduce this plea bargaining and it becomes our legal system, part of our legal system, well defined and all that, they know that you can trace properties to their names, to their family members. What they do now, they will not be doing it, through their family members and all that. So we must be careful. My own decision is that it's a good concept. I mean, somebody becomes an ex-convict, fine. You have him convicted, but for a lesser offense. But we must be careful in application. We're taking into cognizance our own peculiarity, the way we observe law in breach and in obedience. Okay. Where it was working is working in civilized, because these guys, they are good.
Give us your recommendation then. For instance, how would you suggest delays in some of these cases behind it? Because some counsels say that a defendant could enter an objection to some of the amendments in the case, and it could go all the way to the Supreme Court without the main trial even happening.
If Nigeria wants to ensure that we fight an issue of corruption, people have been making suggestions that we should have a different court that should not, special court that will be for issue, and then we must amend our laws in order to not allow all those loopholes, because our legal system as it is today gives so much room for the accused person to go scot-free. He applies for bail, gets a liberal condition of bail, and then goes home, enjoy his loot, and the trial prolongs. He comes up with one frivolous objection, technical matter, and then you go to Supreme Court. No, we must amend our law in order to ensure that there will be a speedy trial. You watch all the proceedings that took place when O.J. Simpson committed a crime in America. You watch the one Dr. Murray that killed alleged to have killed Michael Jackson. You watch when this boxer, what's his name, Mike Tyson, despite the fact that he was a very big man in America, and then he was even very relevant at that point in time. See the proceeding, speedy. And then they were there every day. You were watching it on CNN. At the end of the day, there was conviction. What is our own? Our own is that we allow frivolous application to be made by defense counsel, and you go to Supreme Court over that matter. We must amend our law. If we are serious, there is nothing we cannot achieve. So we must have the capacity, we have the willingness to do it.
That takes us back to the table of the National Judicial Council.
Yes. What about them?
About working speedily. The CJN gave an instruction, for instance, says all corruption cases should be done in 6 months. Is it possible that can be done without plea bargaining?
What of your electoral cases? That they give a deadline. You see all the cases that have been struck out. Now, if we mean anything in this country and we have the willingness, there's willingness on our part, and there is a capacity, there is nothing a human being cannot achieve. Now, corruption, we have known what corruption has done to this nation. And it must be in the mind of everyone, including everyone in government, including people outside government, that we must fight, including judicial officers. If they mean well, no judge that has his, that is a Nigerian, that has his right frame of mind will give a perpetual injunction restraining EFCC from investigating a governor.
But the lawyer was the one who went and sought for it.
No, a lawyer sought for it, and a judge sat and agreed.
Couldn't another lawyer have gone to seek the cancellation of that injunction?
Oh, well, the point is that nobody appealed. You know, that's the system we're talking about. We subject many. Somebody has said they have appealed, but I've not seen the appeal up to this point in time.
They eventually appealed.
They eventually appealed, but up to now,
the injunction was lapsed after a long period.
Chamberlain, if we must rescue this nation, it must be a collective effort. Both the lawyers must make up their mind. Forget about the money they will make. We must rescue this nation. It's not about money, because if this country falls, yes, I'm just telling you, or you fall on everyone's head, including judicial officers, including you and I. So we must all guide our decision and rescue this nation. So when it comes to issue of corruption, every judge must sit up, including the lawyers who are defense counsels must also sit up in order to rescue this nation, because this is a problem that has made Nigeria not to make any progress. We are now a pariah nation. That you are repatriated from South Africa is because you have not put your country in order. They are telling you don't come. If there's any way they will tell you don't come to our country, they will now come with issue of fever, whatever, telling you not to enter their country, and deported you because you have not put your house in order. The moment we fight for this nation and make this nation to be respected internationally, I can assure you it must be a collective effort, and everyone begin to respect Nigerians.
Let me ask a question. It's a double barrel question.
Yes.
But first of all, can a lawyer, like for instance, you now, go up to appeal the case of the former governor of Edo State? Or let's say, okay, let's re-examine that case. Can you take a suit?
I will never do that. But I also laugh.
Is it open?
It's not open. It's not open. I'm even hearing that a governor has gone to court, Supreme Court now, or even Court of Appeal, like Oni, that the matter has already been decided by the highest court, that is Court of Appeal. I hear that, but I don't know how he came back again to the same Court of Appeal to ask a matter that has been finally decided. It doesn't happen anywhere in the world. There must be an end to trial. There must be an end to judicial proceeding. You cannot come to administrative a matter that has been decided. You are going back to the court. This is where NGC comes in to discipline some lawyers that take up these cases. We are senior advocates of Nigerians are the one taking up these cases in a matter that has been finally decided by the highest court. They still go back through the back door to open up. We shouldn't be doing this. There must be an end, because you are making the poor man or even the general masses look at judiciary. What is going on there? This matter has been decided. Who is bringing up this case in the long? Somebody, I'm even hearing they are going to Supreme Court over this matter. And remember what happened in Oba's case. The Supreme Court was so angry that the case came before them, and they deprecated the lawyer that brought it. But some lawyers are still collecting briefs, collecting millions of naira, and filing cases that have been decided by the highest court, going back to the same court. So we must stop all this. There must be a collective effort to rescue this nation. Nigeria is drifting. Look at, they are going back again to borrow how much billions of naira. This is the debt that Obasanjo got us out of. We are now going back to that same debt. There must be that consciousness on that to rescue this nation. Nigeria is drifting, and nobody is caring.